Good evening, this is John Milburn, and this is Laws 12065. This is Foundation of Property Law, and we're into week 3. So thank you very much for those of you who have joined me live for the session. And may I say how proud I am of the work that you did last week in the session where you conducted some excellent content, or you provided some excellent content to assist each other. And as you probably know, I was sort of sneaking around for quite a bit of the session, just quietly listening until I couldn't help myself. For those of you that didn't join us last week, the session was not recorded on the Wednesday evening. And there was a specific reason for that. The fact is that it was your session for you to converse, to explore, and I didn't want to put pressure on people by thinking, well, this is going to be recorded, it's going to be on YouTube, and therefore I don't want to make mistakes or say anything. So that wasn't the point of the exercise. For those of you that did contribute, thank you very much. If you weren't able to attend, that's okay. But what you might consider is trying to create some contacts within the unit or elsewhere so that you can join some study sessions, so that you can work on some collaborative approach to your studies. It's very important in practice, and it's the way that lawyers work. It's very collegiate, despite what you might think, and that's the way that I'd like you to develop your skills. So please try to work together if you can, particularly now, some trying times that we're getting through. In that spirit, what I'd like to do is start off with some commentary in relation to the first assessment. Now, I know that I have created some difficulties for you with that first assessment. And just to get your fingers warmed up, I'm going to invite you to tell me what you think are the most difficult aspects of the first assessment. Just a few words will do. And we'll see if we can get some thoughts around the first assessment. What are you finding difficult about it? Amy, yes. The first comments are exactly what I expected you'd say. The low word count. Any other comments? All right. So just on the low word count, it's ridiculously low, 750 words. However, a few things to point out. The first is that it does exclude contributions that you make in class discussions. So if, for example, you answer one of the problems in Moodle, that contribution does not count towards the word count. What you might do is include it in the document as an annexure so that the body of your document contains a response per se to the assessment piece, and the work that you've cut and pasted from your contribution in Moodle is something different. All right, so hopefully that will provide some guidance. The second is that the nature of the exercise is one where I want you to be strategic about this and develop something that is, if you like, a tool. And I use this a lot, those of you that have worked with me in the past, particularly in the first assessment. What I want to have you do is start thinking about answering a problem at the end of term. I know I've said that to you previously, but it's your opportunity to try and put this into practice. So for the first assessment, don't be concerned about what you think I might want, because the way in which I might go about understanding the topic and, if you like, laying out a structure for answering a legal problem around property may be different to the way that you do it. So I'm really looking for you to do something that will help you. So don't be so concerned about the marks. Prepare something that you actually think will help you down the track. In that regard, whilst I'm not usually a fan of things like dot points, it may be, particularly with the tight word count, that you go with dot points. It might be that you refer to a case, and you might know what that case is useful for in terms of answering a problem. Just include a link to the case. So it may be that you identify a particular area of practice and you think, well, I can see that John might create a question on the exam paper around this topic. what are the key statutes? What are the key cases? What are the key principles? What are the key definitions that relate to that? And if I had to answer a problem in relation to this aspect of, I don't know, boundaries between types of properties in a final exam, how would I go about doing that? Now, you might think, well, I'd be looking at the Iraq method. I'd be looking at issues, rules, application, and conclusions. You know that I don't like slavishly applying that in terms of headings in a paper necessarily. You can if you like, but I do very much promote the principle and the thinking behind it. So as you're looking at a particular area of your reading, you come across something you think that could be on the paper, maybe just identify in dot point form what it is that you think is important that would assist you in answering the question. I know that's a little vague, but that's kind of the idea. And if you like flowcharts, that's fine. So you can include as many links to external materials as you like. And the idea is that you will actually use this document for the take-home paper. It will be more than likely the first thing you look at. And I expect that if once you get this started, this assessment piece, provide it to me next week, 750 words, but then expand on it, add in the additional commentary, flesh it out so that it helps you in a better way to answer the problems. So it's, if you like, notes about what you're reading, but in a way that's structured towards answering the legal problems. I hope that gives you some idea of what we're after. Now, I know some of you want to send in drafts, and you know that I don't accept drafts. I know other unit coordinators do, but it's not my practice to do that. So when you submit the work to me, that will be your final work. So please don't be tempted to send me an email to say, look, here is what I'm thinking, am I on the right track? Because I won't provide a response to that. I know that sounds a bit cruel, but part of it is, again, you've got to prepare something that works for you. Now, bear in mind, don't be too stressed about this. It's only worth 10%, and I'm not trying to say that the 10% is unimportant. It is, but it is only 10%. And it only covers a small portion of the work for the unit. The idea is to kickstart you. I want you to get working on this unit quickly rather than be tempted to leave things until you actually start doing some work in week 6. I know you won't be doing that, but you understand the rationale. So are there any questions about what I've said? It's very much an individual project. It's something that works for you, and that answers the Moodle thing. Okay, thank you. All right, so just a reminder, I'm sure you're all aware, the assessment is due on Thursday, the 9th of April. That's correct, isn't it? Next week. And that's 11:45 p.m. Please try not to be late because you will lose some marks as you're late with the material, if should that occur. So when it comes to the declaration about the reading, all that means is you could just have a tick spot. You could just say completed reading. You can just put in you don't need a stat deck. I just want you to say, I have read the material. I have read chapters 1, 2, 3, 4. Just something along those lines. Likewise, with attending the live lectures or viewing the lectures, you can just tell me that you've done that. You can supplement that with a footnote as to the dates, if you like, so you're not using the words up in the material. And if you find some additional reading, then you can add that in with links to the external material where that might be relevant. But again, don't do this to impress me. Do this to help you in terms of answering the material. All right. In terms of the contribution to unit discussions, if you've answered something in Moodle or you've answered something in Q&A, you've assisted, then you can always put that in, as I said, as an annexure to it. So when it comes to describing the key issues, that can be your evidence of going through the process of working out how you would answer problems, which is really 5 and 6 on the task elements. very much the same. All right, any questions on the first assessment? All good, thank you. How did you go with the content from last week's material? All okay? We'll go through it briefly tonight as well. Now, before I move too much further, I should talk about coronavirus and the final assessment. So, of course, in this unit, it was written and structured on the basis that there would be a 60% examination in the final, in the exam week. And as I'm sure you now know, we're not doing that. So we need to have a replacement. And I think I can tell you that there are two forms of assessment that have been discussed between heads of departments and unit coordinators, etc. And essentially, it can either be an online quiz, which is, for want of a better term, almost a direct replacement for a invigilated exam, or it can be a take-home paper. I've opted for a take-home paper, so that's, unless I'm told otherwise, that's what it will be. And I can go a little further. The take-home paper will not be in a window of 2 hours and 15 minutes. It will be, if I get my way, it'll be in a window of 29 hours. The 29 hours for me works like this. Almost always my assessment work is released on a Thursday evening, and it's then due whenever. So I'm proposing at this stage, and I may get in trouble for even saying this because none of this is verified, and these are just my initial thoughts, subject of course to change, but I'm looking to release the paper on Thursday the 11th of June, somewhere around 6 or 7 p.m. and it will then be due on Friday, the 12th of June, pretty close to midnight, which means that you've got the 2 nights and the 1 day to work on it. Okay, so that's the plan for the replacement to the examination. And of course, I'd written the exam before we started term. So I'll need to give some thought as to whether I just simply leave it as it is or whether I make it more difficult. If I leave it as it is, it'll be easy take-home paper. Now, that is not a license to go soft on your work in this unit. I want you to work hard in this unit. You need to work hard on it. It's a foundation subject, so please be prepared to answer any of the questions that might get through in the final exam. Any questions then about the assessment regime, the final assessment in particular? All good? All right. And we know that the second assessment is, it's marked as a quiz, but I haven't made it a quiz. I've made it an almost traditional take-home assessment work. And you've all had a look at the second assessment, I take it? I have released it, haven't I? You've all had a look at it? All right. So as you're doing the first assessment, I guess you'd be thinking about how you might go about structuring an answer to the second assessment as well. Just briefly, some of the things that we talked about last week: equity and law, you should be on top of that. And of course, that when we're talking about foundations of property law, there's a lot of contract law in this as well. So there's elements of statutory interpretation to some degree, but there's elements of contract. And now there is a tutorial up for last week. Is this not the one from last week? Okay, so what happened is this. So last week, I pre-prepared a session, which I uploaded, and that is marked as week 2 on the front page of Moodle and in the weekly pages. So this is week 3, and the session that was actually on the Wednesday night was not recorded per se. I hope that makes sense. Does that answer your question? Good. All right.
Yeah, thanks for clarifying that. I was dropped it for a week, so I'm a bit trying to catch up.
Oh, okay. All right. So at the moment on the front landing page of Moodle is weeks 1 and 2. I'll take those down this evening when I replace it with this week 3. But of course, if you find that it's not on the landing page for Moodle, you'll be able to find it in the weekly ribbon for each of the weeks. Now, from last week, we talked about various forms of property, the distinction between property rights, property interests, that which is tangible, that which is intangible, that can be left by a will, that cannot be left by a will. What do we call that which is intangible, that can be left by a will, or capable of being inherited? The thing that got me to stop explaining to people what I study, incorporeal hereditaments. Yep. Okay. So you'll apart from this subject, you'll never come across those in practice, I'm sure. So from last week, you need to be on top of SNO and mineral holdings. Ensure that you have a good idea of overcoming property rights and compensation for the acquisitions of property. The trick there is to get an idea of that which is property compared with that which is an interest, and try to get a feel for the extent to which property is, the taking of property is compensable, as opposed to restrictions on interests, which may not be compensable by reference originally to the Commonwealth Constitution. I mentioned contract law previously. You need to have a good idea of the boundaries between property law and contract law. The intersection there is probably Cowell against Rosehill Racecourse. You'll come across that case in a number of units that you study, I'm sure. Having a good idea of between licensing and third parties, property rights and privacy, Victoria Park Racing and Recreational Grounds and Taylor. That's a case you'll come across in probably equity as well, and the fact that there's no tort of privacy. So it brings in torts as well. So my apologies if you come across these same cases in different units, but the fact is that they are important. Yanna and Eaton, you'll need to be aware of that, and Davis and the Commonwealth is a useful case as well. All right, so in terms of this week's content, we're dealing with classifications and boundaries between types of property. It's week 3, but it's topic 2 in your material. Just before I start on that, just a reminder that you do need to be aware of the Australian Guide to Legal Citations. Please ensure that you have ready reference to the 4th version of the AGLC, and please have some basic notes that you can access or create for yourself on how to footnote material. One of my little pet annoyances is having to repeatedly say that footnote numbers should appear after the relevant punctuation in the text. So the little superscript appears after the punctuation, not before. Things like that. Make sure that you use some quotation marks to some degree in the body of the text. If you're using a quotation that goes for a longer segment, then you'd normally drop it a line, indent, drop the font size by 1, things like that. Make sure that you understand IBID so that you've got an idea of how to reference subsequent references, and do understand what I mean by pinpoint referencing and get an idea of how to use that. So if anyone has some good material on AGLC 4 and you're willing to share it, that'd be great. Otherwise, you should be able to find access to the material. Does anyone have any questions or comments in relation to how to cite material? Do we all feel that we can do it reasonably competently? All good? All right. If you do have any questions, please generally ask through Q&A. You can send me an email, but sometimes I'll then say, that's a great question. I think if you wouldn't mind repeating that in Q&A, and I'll answer the question there. All right. So yes, I do want AGLC 4 as the way in which you are referencing the material, so thank you. Part of the thing about the first exercise, the first assessment, which follows through to the rest of the unit, is my desire to have you thinking critically like a lawyer. Now, to be a critical thinker, you need to be an informed thinker, but you need to be prepared to have a reasonable criticism. Now, what I mean by that is that as lawyers, it's almost required of you to question, to challenge, and to be brave all at the same time. And that means being prepared to accept criticism for taking a chance, but taking the chance for the right reason. So, for example, in court, if you are on your feet and the bench asks you a question, don't back off and immediately think, well, I must be on the wrong track if there's been this question, or I feel like I'm being challenged on something, and immediately crumble and concede. Because odds are the bench is asking you the question because they actually want to know the answer, and they're testing the waters. They're saying, you know, is this right? What are the ramifications here? So what that means is that you need to have the courage of your convictions as a lawyer, and you need to have the critical thinking skills. The reason I'm saying that is that when you're answering a legal problem, you also need to have that same mindset of being able to put forward an argument, and the test for you is to ask yourself whether you can say that the argument has validity, and how do you support that? Because once you make a statement, the next thing usually is, what's your authority for that proposition? So if you've been through the process of thinking critically, coming up with some ideas, and then being able to support it, then you're pretty much on strong grounds. Remember, of course, that critical skills involves reading the question carefully. So this is not just for this subject, but generally you need, and those of you that have worked with me in the past, you know this, but if the question asks you to interpret something, that's a critical skill, is your ability to interpret. So interpret means generally determining the material facts, the material issues. Analysis is generally the ability to identify hidden features. Evaluation is the ability to assess. Inference is the ability to draw conclusions. Explanation, the ability to communicate results. So just be aware of that and have some idea of what the question is asking you to do. Again, just a little bit more background material. Remember that there are monetary limits for courts and tribunals. Magistrates Court 150, District Court 750, Supreme Court unlimited. QCAT is a bit different because you've got the minor civil disputes, which are $25,000, but other things are in accordance with the District Court limit. So a dispute under the Retail Shop Leases Act in the tribunal is $750,000, so same as District Court. Other things are unlimited, so in the tribunal it can be similar to the Supreme Court in terms of the monetary jurisdiction. Just a quick note about addressing the judiciary. Generally speaking, if you're addressing a judge in court, it's Your Honour. Magistrate in court, it's Your Honour. QCAT member or Mental Health Review Tribunal is normally just member. Privately, if you engage with a judge in a private setting, in a social setting, usually judge is the appropriate way to address his honour or her honour. For a magistrate or member, it's just Mr. or Mrs. Milburn generally. Mr. or Mrs. As the case may be. And my preferred title here is John, of course. If it's in court, it's Your Honour or member, depending on what the circumstances are. All right. So, in terms of ownership, let's get on to week 3 material. The traditional classification and terminology. At 1.67 of your text, the authors say the law of property, perhaps more than any other basic area of law, is categorized by technical terminology. the survival of which is due more to a sense of historic continuity than analytical precision. Nevertheless, the terminology has to be understood, whatever its imperfections, simply because it forms part of the everyday vocabulary of lawyers. Well, I think that statement is true to a degree, but I disagree with the final conclusion. As I said, many of these terms that I'm asking you to consider and read about, you won't deal with in practice. Some you will. So it's hard for me to say, know this one, don't know that one. I mean, an example is Feesimple. Does anyone know what Feesimple means? Have you come across that term, Feesimple? It's something that is specialised, it's technical, it's archaic, but we do use that one very regularly. So what do we mean by Feesimple? Any thoughts? I won't give you a technical answer, but I'll just tell you, generally it refers to freehold land, and it's, for want of a better term, the closest thing that you can have to ownership of property. So if, for example, as a result of signing a contract and having a settlement through conveyancing, you buy a house, then odds are that you will own in inverted commas that property in fee simple, as opposed to, for example, a leasehold. Now, a fee simple comes about as a result of the grant of the property through a deed of grant from the government, through the Crown really, to an individual, and it's then passed on through a series of transfers or some other means, but it's done in usually fee simple. So that one you will come across. Hereditamus you won't come across in practical sense. And what you will find is that there is this difference between legal ownership and equitable ownership, sometimes known as beneficial ownership. If you haven't yet studied equity, that might be a bit bewildering, but I'll try and explain it this way. In the context of that which is on the title deed, if your name appears as the registered proprietor of the property, the land, then for want of a better term, you have legal title, you have legal ownership. It's not full ownership, but let's call it ownership because your name's on the title. Let's say you've signed a contract, you've settled, you paid the money, but your name isn't yet on the title because the process hasn't been completed. Then you'd say that you are the equitable owner or the beneficial owner, and you have an interest in the property as a result of that. So when you're reading the cases, when you're considering the material, then you would find from time to time this distinction between that which is legal interest or right, as opposed to that which is equitable interest or right. Don't be too much off put by that, but generally legal is, it's on the paper, it's there in writing, it's black and white. Equitable means it's fair that you be recognised in that way. I think is probably the best way I can describe it. So when we talk about terminology within the context of real property and the boundaries and the different types of property, that's a very important distinction, isn't it? So one way of distinguishing property is by reference to the legal compared to the equitable or beneficial. Can anyone think of any other ways that you might regard ownership as being divided in different categories, if you like? Any other thoughts? I know that's a bit vague, that question.
Are you talking
yes,
about
Tanya?
easements and stuff, John?
Could be, yes. That's certainly a category. It can be in terms of time, which is the doctrine of estates. It can be in terms of space, which is, strata title, horizontal or vertical. Horizontal or vertical, or it might be between people. So property might be divided between two owners, and then there's the distinction between that where they hold as joint tenants and that where they hold as tenants in common. So there's different ways that property can be considered from different perspectives. And all of these are subject to then other interests, such as Tanya said, the easements or profits a pronda, which is a right to go on and use the proceeds from what the land has developed or generated. So there are different ways of considering the ownership or the interest in property. So when we talk about property interest, we mean every type of valuable right or interest, and it might be real property or it might be personal property in Queensland. Look, a useful case to keep up your sleeve and maybe look at, but it's a little bit tricky, is the state of Queensland against Congu. That's CONGOO. The citation 2015 320 ALR 1. And that's a kind of a useful case to put in as a reference from time to time. So personal property is essentially what we describe as goods and chattels. Real property means land and the interest in land, including fixtures and incorporeal hereditaments. Don't worry too much about that last one, as I said. But it's easier said than done, because if I'm saying that real property includes fixtures, well, we need to have a good idea of what we mean by fixtures, don't we? You've looked at the second assessment. There's kind of a bit of trick to that, I think, in there. I've forgotten. Maybe it's there. I've forgotten what's in the second assessment. But fixtures is something you need to consider. You need to learn about and have a good idea. And there was some discussion about that last week, I know. In terms of tenements, a tenure is to signify the relationship between the tenant and the lord traditionally. So when we talk about tenements and tenure, you will come across that. It goes back a long way to this relationship of tenure, that both the lord and the tenant have an interest in the land. You'll need to have an idea of what we mean by land. So at common law, land refers to the surface of the earth, the soil beneath, the airspace above, and everything that's growing on or affixed to the soil. So anything that's affixed would include buildings and trees and minerals. But all of that, that's all very well at common law, but it doesn't necessarily apply in practice. I mentioned earlier that property is Feesimple is originally derived as a result of a process where the Crown provides a deed of grant to the original, if you like, landowner, and that is then in fee simple. But there are some reservations. So if you look at a deed of grant, has anyone, I know we've got some conveyances in the unit, has anyone looked at a title deed carefully or a deed of grant to see what you actually get for your money? Has anyone had a look at the reservations? Yes, Tanya.
Yeah, the Crown will normally reserve rights to minerals and that.
Petroleum.
Yeah.
Yep. So even though at common law you have the right to, amongst other things, the minerals, bear in mind that in reality, those things are reserved to the Crown. Even though they're below your property, the Crown still has the interest in it. Now, all of that, of course, was subject to considerable change with the doctrine of terra nullius being declared void by the High Court in Mabo. Void isn't the right term, rejecting the notion. So up until the Mabo decision in 1992, the doctrine was terra nullius, vacant land, the Crown had absolute right, and Indigenous peoples had no right to the land. of course, all of that is now completely overturned as a result of the Mabo decision. It is important that you have a basic understanding of what we meant by what transformation there was with the Mabo decision and the introduction of the Native Title Act, and keep in mind how that might have an ongoing influence on property law as you undertake your studies. What it means is, what Mabo really means is this, that whereas under the doctrine of terra nullius, the Crown had absolute right of the land, following Mabo, that can no longer be said. So now in Australia, the Crown does not have absolute beneficial ownership of land occupied by Indigenous inhabitants. And that's now all regulated through the Native Title Tribunal. Some other terminology, messuage. You will actually come across that if you look carefully on a declaration to say that you're buying a property as your first property, for example in Queensland, it defines what we mean by property. In other words, if, for example, someone buys a freehold and it's, this is old terminology, 100 acres, and it's got a little house on it and says, well, that's my principal residence, you won't necessarily get the full exemption on stamp duty, transfer duty as we call it now, because most of the value is caught up in this large parcel of land. So the stamps office will ask you to distinguish between the value of the house and the messuage compared to the rest of it. So the messuage is like half an acre or so. It's the term that means the house or similar structure together with as much land as necessary for the convenient and comfortable use of that house. And different organisations will regard that in different ways. Now, there are some statutes that you need to consider relevant to this area of practice as well. One that you might consider, one that will be topical over the next few weeks, is Property Occupations Act 2014. If you look at section 21 of the Property Occupations Act, this is Queensland, there's the meaning of residential property. So it says residential property is real property, so real estate in rem, to do with the land, used or intended to be used for residential purposes, but does not include real property that is used primarily for the purpose of industry, commerce, or primary production. If you're looking for a definition of what's residential as opposed to commercial, industrial, or primary production, then Property Occupations Act is probably a good place to start. Another thing that you might see when you're undertaking your study in this area is the distinction between Torrens title land and old system land or Crown leases or native title. So these are different ways of categorising and classifying different types of property. So does everyone know what we mean essentially by Torrens title? Have you got a good idea of what that means as opposed to old system title? Can we just have a quick yes or no? Yes, I understand the difference between Torrens title and old system. Okay, we're getting a mixture of answers. I'll just explain it in this sense. I had the privilege of taking conveyancing last time it was offered for Dr. Nankaro, who was on sabbatical, I think, at the time, and I really enjoyed that aspect because we talked a lot about this sort of stuff. But essentially, Torrens title is what we all know as the Titles Office Register of real estate. So if you've bought real estate, you'll know that you will have a title deed. Most of these title deeds are paperless these days. They're just recorded on a register, and it's distinguished by the title reference number. So each parcel of land, which is surveyed, cut up, taken through council, recognised as an individual parcel of land, usually fee simple, it's given a title reference number and it's given a lot and plan number. So if you see a reference to, something like lot 2 on SP survey plan 1, 2, 3, 4, 5, 6, 7, then that will be a title that is Torrens title land. And it works on a system of registration. So once you're registered, once you become the legal owner, under the statute, the Land Title Act, you have priority in relation to that land. Old system is the opposite. There's not too much old system anymore because almost all of the land has been converted to Torrens. But the way in which old system worked is that the original owner sold the property, in 1492 to somebody else, and there was a contract. The new owner kept the contract as proof that they are in fact the owner, and so when the owner at that time came to sell the property, to prove that they actually owned the property, they would produce the contract from the original owner of the land, but so on until such time as we have a situation where for 500 years worth of conveyancing, people to establish their title under old system had to wheel out bucket loads of documents, and conveyancers would pore over these documents to ensure that there is a continuous chain of title. And of course, somebody loses something or there's a fire and all hell breaks out in old system title. So for want of a better term, old system title required you to prove that you have a continuous chain of ownership going way back. Torrens title said, that's silly, let's just make it a system of registration. So we don't care who owned this property in 1872. We really don't care. We want to know who is the owner now, and we'll just look at the title registry, and if it says John Smith and Mary Smith own the property, then they are the owners. So that's what essentially we mean by Torrens title. It's a system where it works on the basis of registration of an interest, and once you're registered, it's, if you like, for want of a better term, prima facie evidence that you are the owner of that property. Now, title in Queensland generally lasts indefinitely if it's in fee simple, but you may have an interest which is leasehold, and there are some places where you acquire a leasehold interest. Now, it might be a lease from the Crown, it might be 99 years, or it might be some other type of lease. If you buy into a retirement village, you might be buying a leasehold interest. The park owner might own the land and essentially, for want of a better term, lease you the property. You build your house on it, but you're actually building it on leased property under special rules. But if you buy a house now in suburban wherever, odds are it's freehold, which is designated by in fee simple. I hope that makes sense, but you've got to be careful. Where I live in Hervey Bay, there's an area around the marina which is leasehold. So if you buy a unit in one of the resorts there, then you'll get a 99-year lease. And at the end of the time, it will revert back to the Crown or the original lessor. It is possible to freehold, leasehold title, if I can use that term, but you normally need to go through a process to do that. And over the years, Tanya says, they have freeholded a lot of that was originally leasehold. And I've seen that during my time in the law. I've seen this gradual progression of leasehold becoming freehold. And when we talk about freehold, I'm really talking about in fee simple, which is the closest thing to absolute ownership that we have. Have I confused everyone, or are we okay? All good? All right. But you need to have an understanding of that. When it comes to conveyancing, just bear in mind that distinction that I mentioned at the start between that which is legal and that which is equitable, because both the common law and equity apply in terms of the law relating to conveyancing. And the general rule is if you've got a real interest in this property, probably saying real isn't a great term, but if you have a genuine or enforceable interest in property, then you've probably got a beneficial ownership. If you're on the title, it's probably a legal ownership. There are a number of pieces of legislation that you might need to consider in the context of real estate, generally, state and federal. State, you may need to consider in Queensland the Land Title Act. I mentioned that earlier. The Land Title Act is the legislation that really deals with the Titles Office, the process of freeholding, conveyancing practice, etc. I also mentioned the Property Occupations Act 2014, and you always want to consider the Property Law Act 1974, the Neighbourhood Disputes, Dividing Fences and Trees Act 2011 is important when it comes to dealing with trees and fences and disputes, and that can have a real impact on conveyancing. I mentioned the Stamp Act, I think it's called the Duties Act now, but Nicola says yes, it's the Duties Act. From a Commonwealth, and also the Planning Act, Queensland 2016. I take environmental law and we do a lot of work around the Planning Act. At a federal level, speaking of planning and environmental law, the Environmental Protection and Biodiversity Conservation Act 1999 is important, and the Foreign Acquisitions and Take Owners Act. At a state level, also the Body Corporate and Community Management Act 1997. Now, I don't know if you got all of that down. The point is that there's actually a lot of legislation to do with this, even though most of the unit seems to relate to issues around case law. Now,
John,
question, yes, Tanya.
You mentioned, John, in our study notes under the fencing obligations, the Act's incorrectly quoted as disputes dividing fences and trees instead of neighbourhood disputes.
Thank you.
Fences and trees.
It is definitely the Neighbourhood Disputes, open brackets, Dividing Fences and Trees, close brackets Act. Thank you, Tanya. Sorry. So there are some mistakes around, but thank you. It is definitely the Neighbourhood Disputes. I deal with that a bit in QCAT. Question about squatters' rights to property. Yes, I want you to know that. It's an interesting topic. There's a case going on at the moment on the Gold Coast where someone has dug up hundreds of thousands of dollars worth of cash. Makes you wonder about cash. Is cash? Yeah. So cash is interesting. I want you to think about that. So, in terms of actual money, try and categorise that in terms of property law. How do you categorise cash? Is it a chattel? Is it a chosen action? Is it both? And when it comes to squatters' rights, there are some issues that might relate to encroachments. Generally, have a look at the Property Law Act, which provides for the remedy to deal with those things. Natalie says cash is a chosen action. Probably is, but I do want you to look at that. Thank you. The other thing that you might want to consider is that when it comes to contracts to do with real estate, bear in mind that there is sometimes a need for a written memorandum or note. Have you come across the Statute of Frauds? Statute of Frauds basically requires, this is old now, but it's incorporated into our law. Statute of Frauds, which is repealed, basically said you need to have something in writing when it comes to transactions involving land. Unsurprisingly, given that I said previously that under old system land you had to have a bundle of papers to show that you owned the property. So therefore the law said, well, it's got to be in writing, otherwise it's unenforceable. Have a look at the Property Law Act Queensland. Have a look at sections 11 and 59, which both to some degree deal with that issue. And Section 11 primarily deals with ensuring that an equitable interest in land could be transferred by written document. And Section 59 has practical application where it says that where you've got a contract for the sale of land, it's subject to the rule that it must be evidenced in writing. And so Section 59 deals more with the enforceability of an agreement, and it requires a contract. The contract doesn't have to be in writing. I'll correct that. It doesn't actually have to be in writing, but what you need is something either in writing or a memorandum or note evidencing something in relation to it. So have a look at sections 11 and 59 in that regard. Nicola says, yeah, build a deck up a block where there was some constructing a house, and that is the case that I was thinking of. In terms of the content for week 2, fixtures are important. In order to better understand fixtures, you need to consider the degree of annexation test and the purpose of annexation test. So what that means is determining the extent to which the property that is fixed is affixed to the land and why it's there. And I know there was some discussion last week about things like solar panels, things of that nature. So generally speaking, if it's affixed to the land or something that's affixed on the land, like a house, it's a fixture, which means that when the property is sold, the fixtures go with it. If it's a chattel, if it's a fitting, which is the contrast to a fixture, then generally the seller of the property can pick it up and take it away. So it's that, of course, when it comes to an exam question, we're always testing the grey areas in that regard. And so the degree of annexation test is important, and the object or the purpose of annexation test is important. So in your study guide, there's the case of National Australia Bank and Blacker and Pullenberry and Pullenberry from 1986 as well. I think that's also in the study guide. One little problem relates to tenants' fixtures and the right to remove fixtures. In other words, it might be something that's fixed, but it's not the owner of the property, it's a tenant. So that creates a whole lot of other issues. And that's, again, a lot of these things are sorted out in QCAT, in the minor civil disputes jurisdiction. When it comes to boundary fences, which is encroachments, it kind of borders on to the area of adverse possession. So just try to have a good understanding of what we mean by a claim for adverse possession as opposed to an issue to do with an encroachment. Now, what I mean by that is this. If, for example, people have built something, let's say a tennis court, for one of, so somebody builds a tennis court and it's there, but they've actually encroached onto the neighbour's property by, I'm sorry, I still talk in old language, 6 inches. You young ones won't know what that means, but you have to Google it. So it encroaches onto the property and it runs for, now I'll switch, for 10 metres or 20 metres down the property line. Can that person claim adverse possession in relation to that strip of land, or does the law in Queensland require to deal with that differently, which is an encroachment? And the answer is encroachment. So when it comes to that distinction between adverse possession and encroachment, as a general rule, you can only be looking to claim for adverse possession if you're claiming ownership of the entire property, as opposed to a little strip of it, which is more an encroachment issue. Sometimes you might hear this description of boundaries. So we're supposed to be talking about boundaries between properties. A very old-fashioned form of description between boundaries is meets and bounds. Paul Kelly wrote a song, Meets and Bounds, didn't he? Any fans of Paul Kelly? So meets and bounds. Meets and bounds description is where you set out various descriptions about fixed points on the ground. You know, so many meters from the edge of the creek or a boulder or from a tree or something along those lines. I actually came across that once where in assisting a property developer years ago when I was doing property law, we needed to undertake a meets and bounds description in a contract. So that was the one and only time it actually came into practice for me. The other thing that you need to consider is the doctrine of accretion. Now, this is particularly relevant in the context of something we'll be doing later in the unit, which is to do with the Personal Property Securities Act 2009 Commonwealth. That's a really important piece of legislation. So I want you to start thinking about that piece of legislation as we go. Accretion means, in relation to goods, things that are installed into or affixed to other goods. So they become part of that other good, if you know what I mean. So a car is a motor vehicle. It's not a chair with something wrapped around it, if you understand what I mean. So the chair in which the driver sits is there as part of the motor vehicle. It's not there as a standalone chair that happens to be attached to a car. In other words, if you sell the car, the owner of the car can't say, well, I'm keeping the steering wheel or I'm keeping the chair. No, the doctrine of accretion would say they now form part of the thing that's being sold. All right, and some of you need to leave and go. So I think we're just about there now. Are there any questions, comments? All good? All right. When it comes to encroachments, have a look at Part 11 of the Property Law Act Queensland 1974, and that should do us. Thank you very much. We'll see you next week, and good luck with your assessment, and stay well. Okay, bye then.
Hey, John.
Yes.
I've noticed that the assessment, you said it's due next week, but on the website it says it's due on the 9th of April. That's actually 2 weeks.
Oh, is it 2 weeks? Sorry, I'm losing track. You're right. No, you're right. So it is due on the 9th of April, whenever that might be. So that's in 2 weeks, is it?
Had me freaking out there. I only just
I'm sorry.
trying to catch up. All good.
Thank you. So those of you watching, those people that are watching this as a recorded session will be freaking out unless they watch right to the end. Yes, 9th of April. You're right. Thank you, Nicole. Okay, we'll see you next week. Bye then.